Well, thank you. I just said a whole intro. That is hilarious. Well, hey, it's your girl, your favorite paralegal, aka Cassandra Lead, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Wednesday. I just decided to hop on to kind of give you guys an update on a new filing in the Jay-Z case where he was actually named as a defendant with Diddy Combs in regarding the alleged 13-year-old who was great and essayed, and Tony Buzbee actually ended up filing a amended complaint to include him in that. Now, here's the thing: they have been fighting tooth and nail trying to get this case dismissed, but there is a level, not a level, but a process of on which you do things. So we're definitely going to get into that. So I got my Marvel gear on, as y'all can see. Spider-Man. I don't have a favorite Marvel character. Got my Avengers cup. So we about to get into this. All right. So let me share my screen. I'm gonna share this. Okay. So before we get into anything, what are sanctions? Sanctions are, how can I best put this? If an attorney doesn't follow certain procedures to the court, whether it's state level, whether it's federal level, if they do some things that will cause them, like if they don't file responses, or if they don't file pro hoc vice, or they're not admitted in a certain district, so on and so forth, the other attorney can file for motion for sanctions. Depending on the severity of it and depending on whether or not it is a repeated offense, then they can take things a little bit further. And when I say they, mainly the judge or whatever district they're in. So the judge will have the last say so. So it may be something where the attorney has been told time and time again by the judge that they shouldn't do this and that. And they will say, okay, well, we are going to submit a grievance to the state bar. And if it's even worse than that, then they can face some type of disciplinary action. I don't see Tony Buzbee actually being, um, you know, going outside the normal, okay, you have to pay a fine to the other side, or to the plaintiff. At the most, the judge will be like, okay, you will have to pay $3,000 by such and such date, and that has to go to the plaintiff's attorney. I mean, not the plaintiff, the defendant's attorney. And that's it. So it's not something where it's going to get Tony kicked out the case. I don't feel like he's going to face any type of disciplinary action. I don't even think that his bar license will even be reviewed or even thought about, being revoked. All right. So I just wanted to put that out there. But this morning, Alex Spiro has filed a notice for a motion for sanctions. Please note that any type of motion that is filed with the court has to go before the judge. So this is just a motion for sanction. It's not saying that Tony Buzbee, is going to be sanctioned. It is just Alex putting a request to the court to have Tony Buzbee sanctioned. Let me turn off this. And so we're going to get through this. I ain't going to keep y'all long because I do got work to do. All right, so all right, so notice of defendant Sean Carter's motion for sanctions and to strike the complaint pursuant to Federal Rules of Civil Procedure 11. Please take notice that upon the accompanying memorandum of law, declaration of Alex Spiro, and accompanying exhibits, and any other arguments to or materials that the court may consider before this motion is taken under submission by the court. Defendant Sean Carter will move this court before the Honorable Annalisa Torres and at a date and time determined by the court, blah, 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 for an order dismissing plaintiff's amended complaint pursuant to Rule 11C of the Federal Rules of Civil Procedure, to imposing monetary sanctions. So that's all they're asking for. They're asking for Anthony Buzbee, aka Tony Buzbee, to be fined, directing the parties to confer regarding a briefing schedule for the determination of Mr. Carter's reasonable attorney fees and costs, and such other and further relief the court deems just and equitable. So what they're asking is several things. You know what? Let me, because I don't want to say go back and y'all review the Rule 11, I mean, the video that I did in regards to the Rule 11 sanctions. But for those that are here, where is it at? They said Rule 11C sanctions. Limitations on monetary sanctions. The court must not impose a monetary sanction against. Okay, that's nothing. All right. So that's all it is. All right. So he's asking for the complaint to be dismissed. He is asking for Tony Buzbee and his firm to get sanctioned, meaning a fine. They are also asking for them to get together in order to determine how much money Jay-Z has spent just in regards to his part in this case. Because more than likely, if Tony Buzbee does get sanctioned, he's not only going to be subject to a fine, but also to pay whatever attorney fees and costs that were associated in fighting this particular case. And then whatever the court deems, just in this matter. So that's that. Now, what is very interesting is the supporting documents that Alex Spiro actually submitted. And I'm just going to kind of give you guys a brief overview of what was filed, because I was like, child, they are really, really trying to discredit Jane Doe in regards to everything that she has been saying, because she even had admitted that her story has some inconsistencies with it, right? But Spiro is saying, okay, we want this case dismissed. We want sanctions against Tony Buzbee because he ain't doing what he was supposed to do. He didn't properly vet the client and so on and so forth. And I did a video with Tony Buzbee's statement to that. But once again, Spiro has included in this motion for sanctions supporting documentation to prove and to support why this case should be dismissed. When I say, a lot of people are saying this case is not going to be dismissed. Good morning, Gold Digger. Good morning, love. Yeah, so a lot of people is thinking that this whole case is going to be dismissed, and that's not the point, or that's not the goal. For the simple fact, there are other defendants in this case. This is not a case where it's just Jay-Z. If you look at the parties include Sean Combs and all his entities, and Sean Carter. So all Spiro is asking for is for Sean, or Sean Carter, or Jay-Z, to be dismissed from the amended complaint. So let's say that the judge does say, okay, we will dismiss the amended complaint that names Sean Carter. The case against Diddy is still going. Okay. So they're not dismissing the case. They're only dismissing the amended complaint that named Sean Carter as a defendant. So with the support, they included the NBC article. They included the Lotus nightclub's photo, screenshots from the award ceremony video footage, screenshots of the limousine from the award ceremony, screenshots of the vicinity of Radio City, a transcript of October 3rd, 2024, the Chris Hansen show interview, a transcript of the October 1st, 2024 press release, photos of the Twirl nightclub, the ACRIS search results, and that's dealing with property records. December 11th CNN article, 813 Park Avenue photograph, transcript of the April 28th, 2024 document. Oh, wait. documentary interview, LexisNexis county deed, and the Hedge Bank's drive photo. Oh, you know what's crazy is that I was going through my little rabbit hole, and I actually pulled up Hedge Banks because it also has a U-shaped driveway, but it's no buts. It has a U-shaped driveway and it is a white house. And I was thinking, well, maybe what if it's this, but it is outside of the New York City limits because it's in the Hamptons. Oh Lord, hold on. Let me text this attorney right quick. Good morning. Do either of you all have a consent to associate for referral cases? I need to check. Yeah, that's the thing. Attorneys can text you at any time. I need to check. I think I have a referral. Okay. Anywho's my bad, y'all. Yeah, so I looked that up. So I don't know. We'll see. We'll see. All right, so let's get back into the documents. Da-da-da-da. All right, so here is Alex Spiro's support for his motion for sanctions, dismissing the complaint pursuant to the Rule 11 of the Federal Rules of Civil Procedure. I ain't gonna read it because it's like 30 pages, but here's the argument that Spiro is trying to make. The court should impose Rule 11 sanctions for Mr. Buzbee's filing of the amended complaint and refusal to withdraw it. Says A, Mr. Buzbee violated Rule 11B by either filing a knowingly false complaint or failing to conduct a reasonable inquiry into the facts. Their second argument, or part of that argument, is that the court should dismiss the First Amendment complaint and impose monetary sanctions against Mr. Buzbee. Hold on, let me take a sip of my coffee. Well, I didn't want y'all to hear me sipping. Gold Digger said, I thought about how Jane Doe has been honest. She's not hiding her inconsistencies, but a whole lot of her remembering is on point with 2003 being more like the year not 2000. And that's what I said. But you know the crazy part is that they also talked about her autism, how individuals who are autistic, times and dates are not something that they are good with. So that could be, something that we have to take into consideration, as well as the time period. This is over 2 decades ago. This was literally, now, I know that we should know, and I can only speak for myself about traumatic experiences or, experiences that were really, really awesome. We tend to remember those versus the day to day things that we do. So, like you said, she has been honest and say, yes, there may be some inconsistencies, but we have to realize that this is over 20 years. Furthermore, when we file cases and we don't have all of the documents or the facts or anything to back up that story, it's not saying that she is lying. Okay? That is why we go through the litigation process, because during the discovery phase, we get everything that we need in order to support the plaintiff. Look at DJ Academic's case, right? We now there has been videos circulating, okay, but y'all have to realize that some people are not into DJ Academics, so they're not going to go on his YouTube. They're not into, some of the cultural things that we do. So they're not going to go. There's life outside of YouTube. So they're not going to go scrolling on YouTube to find a video that, has been circulating about DJ Academics. So therefore, when the young lady filed her lawsuit, right? They asked, and they got to the discovery phase, they asked for documents, videos, audios, and responses to questions. That's what we use in order to we go through there, we, line by line, screen by screen, photo by photo, and we take that information and we try to piece it with what the plaintiff has told us. This is the same case here. Everybody was like, well, there's not enough evidence. We haven't even got to discovery yet. Last night I reported that I forgot who's did Busby file? Somebody filed. Somebody filed yesterday. And I just want people to realize that a plaintiff cannot move forward without certain evidence. Give her an opportunity to get to the the discovery phase. A demand letter was sent prior to this filing of this lawsuit. Okay? That demand letter asked for a confidential sit down. It was no monetary, and people I'm trying I try not to be frustrated, but I have to understand that everybody is not in the legal field, okay? It is customary for demand letters to go out during a litigation process when you're dealing with civil litigation. Okay, I don't care what it is, if it's a wrongful death, if it is a car wreck, if it is a slip and fall, if it is an SA, whatever the case may be, it is customary that we send out a demand letter. There have been very few demand letters that we have sent out requesting for a pre litigation mediation. It does not always have to result in a monetary demand. They just wanted to collect the evidence because obviously that is part of trying to get more information to see if litigation is even needed. Because they could have sat down, you know what I'm saying? Jay-Z and whoever, I don't even know how it said confidential. So I don't know how that would have worked. But however it did work, she could have been like, oh, okay, well, da 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 da. And something could have been revolved. Oh, it's the wrong person, or he wasn't there, or whatever the case may be. But they did not give her the opportunity to even have that confidential meeting. So, therefore, in order to get a response from the other side, what we do, we file a lawsuit and we put that in the demand letter. If you do not agree with this meeting, or you do not agree with this demand, and no response is received, we're going to file a lawsuit. All right. Now that goes back to this part right here. It says Mr. Buzbee violated Rule 11B by either filing a knowingly false complaint or failing to conduct a reasonable inquiry. I did a video on that. What Buzbee already said. She went through she went through a full vetting process. She went through that. She's already been vetted through I don't know if it was 5 firms or 5 attorneys, but she was vetted. And knowingly false, well, we asked you for a meeting to sit down and talk about this, and you refused. Let's go on to 13. Let me see what's page 13 so I can get y'all out of here. What this preliminary statement. All right, so while the allegations stated in the complaint in this case are gravely serious and injurious to Mr. Carter's hard-won reputation, many of them on their face strain the outer bounds of credibility, and none of them appears to have been subjected to even the most rudimentary diligence by the filing attorney who initially signed his name to them and has since declined to withdraw them. Because the federal rules and professional ethics require more of a filing attorney, Mr. Carter now respectfully seeks appropriate sanctions. Federal Rules of Civil Procedure 11, Rule 11, Paragraph B, Section 3, requires every attorney who signs a complaint to certify that, to the best of their person's knowledge, information, and belief, formed after an inquiry, inquiry reasonable under the circumstances, the factual connections have evidentiary support or is specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. As judges in this district and elsewhere have long held, plaintiffs may not file a complaint in this court without having a reasonable investigation of facts. That rule accords with the rules of professional conduct, which prohibits an attorney from knowingly asserting material factual statements that are false. Let me see. New York rule, professional conduct 3.1 states, and from failing to correct a false statement of material fact or law previously made to the tribunal of the lawyer. My thing is, like I said before, she has came out and said that there are inconsistencies. But if she's telling the same story through five different lawyers or five different law firms, like what more can she have done? That's the whole process. That's the whole purpose of getting to the discovery phase. This is crazy. Gold Digger said, yes, with autistic people, time and dates are an issue. Spiro should do his homework with regard to the autistic plaintiff. Cognitive is a main issue with autism, and trauma to it is magnified. Yes, he should have taken the confidential meeting. I agree. Yes, y'all definitely support. Definitely hit that like button. That's all that is free. That's all y'all got to do. And hoping your day is going smoother, even though it's 10:13 where I'm at. All right, so the basic guardrails in litigation are critical to the integrity of the judicial process. Courts rely on attorneys to conduct a reasonable investigation into the facts alleged in a complaint to avoid wasting judicial and party resources litigating meritless claims. They Let me see. They cited Bus Guides Inc. and Chromatic. I don't know what is that. Something enters where it was stated that Rule 11 is aimed at curbing abuses of the judicial system. They also quoted Cooter and Gill versus Hartmax, where they stated that the central purpose of Rule 11 is to deter baseless filings in the district court. My thing is, why do y'all feel like these claims are baseless and meritless? Moreover, in cases where the allegations assert outrageous or criminal conduct, an attorney's certification that the allegations are reasonable, supported by evidence, ensures that parties cannot improperly use statements in judicial filings, often shielded from defamation liability by the litigation privilege, and impugn the reputations of innocent people or attempt to extract unwarranted settlements. My thing is, I get what they're saying. However, these are just regular cases that they're citing. What case similar to this case can you have cited? Y'all see what I'm saying? So these are like general rules. These are general rules. But what about rules specific to SA? Okay? Because you have to think about it. An SA case is not going to be the same as a case of a breach in contract or a car wreck case. It's not the same. SA cases are very, very sensitive cases. Spiro don't want the evidence to be revealed. I think they know it will end his career. And that's probably why they doing all this shenanigans. If y'all haven't watched my video last night, Tony Buzbee filed a second lawsuit against Rock Nation and that MG legal and stuff like that. That's my thing. They're working overtime trying not to get this uh out. I believe that. But yeah, so like I was saying, it's good that you are citing these cases, but once again, you have to think about the nature of this particular case. How can you say that an SA victim's her facts, her alleged facts, are meritless and baseless? They also cited Ursherson and Banshell where sanctions was warranted, where counsel. Oh wait, hold on, I done missed the whole thing. Hold up. Uh, Moreover, in cases where the allegations assert outrageous or criminal conduct, I think I already read that. Oh no, I didn't. An attorney certification that the allegations are reasonable, supported by an evidence, ensures that the parties cannot improperly use statements in judicial filings, often shielded from defamation liability by the litigation privilege, to impinge their. Oh yeah, I did read that. All right, so China versus DL Piper. It said that sanctions appropriate where claim can only be viewed as attempt to harass defendants and cause reputational harm. So what they're saying is by her filing this lawsuit and Buzbee not properly vetting her to ensure that the facts was straight, that they are harassing Jay-Z and causing reputational harm to him. And Spiro is asking them to sanction Buzbee because of this. Then in another case they cited Usherson versus Banshell Artist Management. Once again, nothing to do with any SA case. Sanctions warranted where counsel maintained the lawsuit without any investigation, indicating broad strategy to use burdens of litigation to extract settlements, even in frivolous and unmeritorious suits. Once again, this lawsuit is very different from the ones that you are citing in this case. I honestly don't believe her claim, and Buzbee is not on the up and up due to his other lawsuits against athletes. His own record is. And I get that. However, y'all can't sit there and look at any other lawsuits. Like, each lawsuit is handled differently. No lawsuit is going to be the same. So, because what he's doing in another lawsuit does not, it can't spill over into this particular lawsuit. Like, we're not, how can I say this? All lawsuits are treated on a case by case basis. We don't treat anyone less than the other. However, we do pay special attention to cases involving SA and even wrongful death and some personal injury depending on that. So once again, everybody is saying that, and it's fine. You don't have to believe her claim. However, let her get to the discovery process. Why people don't want to go through the litigation is beyond me. That is beyond me. That part, they don't want evidence to come forth. They're fighting hard to get this entire case squashed before it even goes before the judge. But see, that's the thing. It's not even the case because Diddy is still. This is a case with Diddy and his entities, and Jay-Z just happened to be named as one of the defendants. So the case is not going to be dismissed. It's only going to be the First Amendment complaint that gets dismissed, but the charges are still going to be, and I say charges, the case is still going to have Diddy and his, his entities on there. So it's just like Diddy, I mean not Diddy, but Jay-Z is throwing Diddy under the bus. Like, hey, I ain't got nothing to do with this. I ain't do nothing with this. This was all Diddy. That's all it is. Why didn't the first firm represent her? Buzbee says she was given to him. Y'all have to understand, and just like if y'all was in here, the attorney, he asked me, did I have a referral agreement? We do that all the time. Y'all have to understand that not all law firms handle certain cases. So for us, even though we handle civil litigation, we do personal injury such as slip and falls, car wrecks, did I say wrongful death? Wrongful death, Uber cases, but we haven't done any SA cases. Now, we may say, or I may say, hey, I know an attorney that does handle nothing but SA cases. So that is why it just depends on the severity of the case, the workload, and if the attorney or the firm actually handles that. You don't want to go to a firm and they never handled an SA case. Y'all have to look at Tony Buzbee file. He is a national trial attorney. He handles all, he has several practice areas, and he is good. So that's why. So just because we get a case, we don't have to take it. That's number one. But we may say, we may refer your case to somebody who we know is, who specializes in this particular type of case. I'm just saying, if your question tactics of spiral, should, no, that's what I'm saying. And I've read, if you've gone and you watched the video for that, if he did what he did in those Jones Act cases, then he gets to what's coming from him. But that does not make, well, how can I say that? Like a shady attorney. I don't want to use the word shady, but it is questionable. Like, if you did something that you're not supposed to do, of course. But those are totally different cases versus this SA case, if that makes sense. Again, facts may be a bit scattered as a result of Jane Doe being autistic, but it doesn't mean it didn't happen. Correct. I wonder if the fight with Bay's sister about him cheating with child, I don't know, but baby, that elevator altercation is something. All right, so plaintiff's lead attorney Anthony Buzbee has violated Rule 11B by either knowingly making false allegations about Mr. Carter in the amended complaint, failing to conduct an adequate investigation into the complaint's factual allegations, or at minimum failing to withdraw the complaint once it became clear that numerous allegations in the complaint are false and the other allegations are therefore at least highly suspect. Oh, yes, ma'am. Yes, I love a debate. Yeah, so I have a whole playlist, so it makes it easier. So definitely go back and watch that. Yeah. So Busby, I was on him. If he did do what they said he did, he definitely needs to be held accountable for that. I don't like attorneys that try to take advantage of the situation. All right. Let's talk about this complaint. The First Amendment complaint alleges that following the 2000 video VMAs, that's what I'm gonna call it, plaintiff was rugged and raped at a celebrity party. But almost immediately after the FAC, which is the First Amendment complaint, was filed, NBC News journalists determined that a number of allegations were either false or highly doubtful. Now, these are journalists. I'm not putting anything against journalists or the court of public opinion. However, they would have to do significant research in order to determine that her allegations was false. Like, yes, she said one thing here, but in the interview you said another thing. But once again, that goes back to allowing her to go through the discovery phase, where you have the experts to sit down and speak with her, and you are allowed for investigation to happen in order for the facts to come out. And then whether or not the case can be dismissed at any time, but let her go through the discovery phase so that we can get to the nitty gritty. Sharing a true example, my niece took an Uber. Oh man, what? Those Uber cases? That I'm gonna have to pull a Uber case, and we might have to do that. But it's really sad what goes down in those darn Ubers. For example, paragraph 44 of the complaint claims that the party occurred at a large white residence with a gated U-shaped driveway. That was approximately 20 minutes from the VMAs by car, but photos show that after the VMAs, Mr. Carter attended a party at Lotus, a nightclub in New York. And then let me see. Oh, they attached the article, so that's the article, Exhibit 1. Paragraph 60 states that after the alleged assault, plaintiff father drove to pick her up, but the father has no recollection of doing so, despite the fact that it would have been a 10-hour drive round trip to retrieve his 13-year-old daughter from a random gas station. Paragraph 46 states that the plaintiff spoke to celebrities at the alleged party, but when journalists pressed her as to which celebrities she spoke with, she named a person who was in Chicago that evening performing a concert. Paragraph 40 states that the plaintiff watched the VMAs on a Jumbotron. In fact, photos from that evening show where there was no Jumbotron, as New York City had denied MTV a permit. And the same paragraph says that plaintiff approached limousine drivers at the VMA, but video shows that the limousine area was uh, cordoned off by police and inaccessible to fans. All right. So, by any objective measure, the fact that nearly every step in the plaintiff's narrative, from her arrival at the VMAs to her interactions with the limousine driver and celebrities to ride with her father, turns out to be false or highly likely, casts considerable doubt on plaintiff's allegations that Mr. Carter raped her, which he did not. Confronted with those galling red flags, a competent and ethical attorney would have not only omitted the many erroneous allegations from the complaint, but also completed a thorough and careful vetting of the core assault allegation before affixing his or her signature to the complaint. Abiding by the ethical duty was especially important here given the defamatory character of the assault allegation and the near certainty that complaint would generate massive publicity in light of the identity of the defendant, inflicting irreparable reputational harm and forcing him to explain to his own children that he had been falsely accused of assaulting a child. And conducting a thorough inquiry is particularly critical where, as here, the plaintiff has no corroborating witness for her account and claims that she did not tell a soul about the incident at any point in the last quarter century, including her father, who supposedly picked her up. They cited Saltz versus the city of New York, where counsel must rely on his client. He has an obligation to question him thoroughly, not accepting his version on faith alone. Once again, we have to take a look at cases similar to this one. I'm just saying. But it appears that Mr. Buzbee failed to conduct any such inquiry. That a reporter was able to undercut almost all of the events of plaintiff's narrative just 5 days after the First Amendment complaint was filed only highlights the complete lack of investigation undertaken by her own attorneys. A simple call to her father, a review of publicly available video footage and photos from that night at and after the VMAs, or a view of publicly available property records would have quickly revealed that the implausibility of her allegations. Mr. Busby has all but admitted that he declined to undertake such a basic investigation. He actually came out and said that she was vetted. I'm so crazy. Oh, nobody's saying that there was a Uber. If y'all go back and read what Gold Digger said, then you'll understand why she uh said the Uber. Uber from Cali to Arizona to say hi to a friend. She's autistic and her actions actually put her in danger. She was a teen when she did this, then took an Uber back to Cali. Oh wow. Imagine the amount of money it costs to Uber there and back. It's not a normal thing to do, and her parents didn't know she did this until they got a charge on their credit card. What? See, anything could have happened. Anything could have happened. And she didn't. She didn't. Oh my gosh. That is all. And she's autistic. Oh man. Oh, poor baby. Poor baby. Golly. That's crazy. Mm. It was something that I wanted to say too. And we, unfortunately, because she didn't tell anybody, it's not like we can go back to the gas station that she went to and pull footage. In these car wreck cases, the first thing I do is I ask them where was the incident or where was the accident, and I pull up a Google Maps or I search and I try to find any location that may have had a camera. Do y'all know that some people have cameras just for show? They don't be rolling. Some people have surveillance cameras, but it re-records like between every 9 to 12 hours, or it automatically erases after a 24-hour period. I'm like, what? So That's one way that we could corroborate her story. But unfortunately, here we are a decade, what, 2 decades later. There's just no way to get that unless she would have called the police when she went to the gas station. But that's neither here nor there. Da 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 da. Okay, when confronted by NBC News journalists with a series of false allegations in the complaint, Mr. Buzbee sought to recover for his utter lack of diligence by claiming his client would undergo a polygraph examination, an offer he seems to have abandoned since making it weeks ago. And he's passed the buck, stating that another unnamed firm had vetted the allegations that the Buzbee firm would continue to vet plaintiff's claim and collect corroborating data to the extent it exists. That is entirely improper. It was Mr. Busbee's responsibility to conduct a factual investigation into the allegations before he signed the complaint, not afterward, and he cannot evade the core ethical responsibility by relying on the work of other attorneys who did not sign the pleading and are not associated with this firm. Um, and I just want everybody to know this is an essay case. We cannot treat it as a like any other type of civil case. You just can't. With these type of allegations, you can't. I can see if it was, a breach of contract or, another type of civil litigation, but for an essay case, I don't see it. Uh, all right. So they're just mainly talking about him signing a pleading or a petition and submitting it to the court, knowing that the facts are, well, not the facts, knowing that there are lies being told. Let's put it that way. Moreover, although Mr. Buzbee claimed in his statement to the journalist that his firm had interrogated plaintiff intensely, she admitted to the journalist that she had made some mistakes and was guessing about key details, serious problems with her account that Mr. Buzbee would have uncovered had his firm actually interrogated plaintiff. Instead of conducting a thorough investigation, Mr. Buzbee filed a complaint setting forth one of the most serious allegations of criminal conduct imaginable, and with an accompanying publicity campaign on social media and elsewhere, based on an uncorroborated claim of assault that relied on an easily disprovable factual narrative. And explicitly, even though the NBC News story was published over 3 weeks ago, Mr. Buzbee has taken no action to withdraw a complaint that contains provably false statements. You know what I think? I'm just thinking through all of this, and I don't know how they can, check, but Diddy hasn't said anything. Diddy has not said, no, Jay-Z wasn't there. And I know Diddy talks because just last night they was talking about how he's upset that Luigi is getting all this attention and he's rooted as a hero and he a little jealous. So I know Diddy talks. Diddy has not once said Jay-Z was not in that room. I wonder what his response is when he got filed. So I need to see what his answer is because this is Question: what's the chances of someone not seeing a 13-year-old white girl walking down the road at the time of morning and not call the cops or stop to help? Oh, hey, you right. You right. Trust me, I done went down my own rabbit hole. I have went down my own rabbit hole. So I'm just sitting back and observing like everybody else. Cause I'm just like in the middle of the night. Like now, I'm gonna tell y'all, I personally thought that she was referring to because if an autistic individual does have problems with dates and times, not trying to figure out, but determining how much time it takes to do something or go somewhere or anything of that nature. I was like she said, the car ride was 20 minutes. What if that car ride was 2 hours? but it felt like 20 minutes to her. You see what I'm saying? Because my thought process, she said it was a white house with a U-shaped driveway. I pulled up the Hamptons and bam. Now, the only thing I can't prove, because I'm not there, I can't prove that there were any gas stations in that area at that time. Because when I pull up the map, I see nothing but houses and I don't see a gas station in sight. So again, yeah, I mean, I get what you're saying, Fernando. However, that is why we get to the litigation part, because you're going to have experts in certain fields that are needed in order to pick a piece, her story, and try to connect the dots with it. Hey, Queen Grandma, how you doing? How you doing? How you doing? Right? And why would baby filing for divorce? I heard that, but I don't think they filing for no divorce. She ain't about to divorce him. But why Jay-Z sitting there, hey, y'all heard about the mergers and acquisitions that's going on? I promise you it was people leaving that party at that time and would have seen it. Oh no, I agree. I agree. But we got to think about the extent of the people leaving the party, child, because I'm pretty sure, was there any sober person at them parties? Mm, I'm drinking my coffee. If my child was missing, I would have called the cop. She was missing for a while. And that is another thing. And I don't know, because me, I'm a nosy mom. I hear everything. So, but thank the Lord I have awesome kids. But as a parent, how you know your child wasn't gone at the age of 13 for that darn long? Now they did say the father during back in them days, something was going on in that little area. So he could have been under the influence of something. I don't know. Allegedly. Allegedly. That's cap. It's obvious to me that Busby know his stuff, because he definitely said that other celebrities sit there and watch. Who is the celebrity and why haven't they come forth? Baby, let me tell you something. There's another case that I'm going to get into, y'all. And I've been eyeing this case, and I was trying to wait to present it, but it's out now. It is a case where a Michigan man has sued Diddy, and I have gone through the records. Like, this dude ain't lying. This dude got receipts. Do you hear me? He supposedly named J Lo during that time, but we'll get into that. We'll get into that. There you go, Cassandra. Also, autism doesn't take a vacation, and as an autistic adult, I'm sure she still struggles with time, dates, and distance. Yep, we shall see. All right, so let's see. I don't even remember where I left off. Da, 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 da. Okay, I think I said that. None of that is acceptable for a member of the bar of this court or any other court. Now y'all saying he's a member of this court. That's funny. That is perhaps why Busby. Oh, never mind. I lied. None of that is acceptable for a member of the bar of this court or any other court. That is perhaps why Mr. Busby has not obtained admission pro hoc vice, despite having signed numerous pleadings and other filings in 2.5 months since signing the original complaint. Indeed, although Mr. Busby advised the court on December 20th that he was admitted to practice in the Eastern District of New York and intended to apply for reciprocal admission to the Southern District, he has not even sought interim admission pro hoc vice while his application is pending, despite signing more filings over the ensuing weeks. Whether that reflects an improper effort to avoid the jurisdiction of this court or just a failure to act with anything approaching reasonable diligence, it reinforces the propriety of imposing sanctions here. Given the horrific nature of the allegations in the First Amendment complaint, every day is inadequately vetted complaint remains on the docket, causing extraordinary harm to Mr. Carter, his family, his businesses, and his employees, especially when a complaint alleges violent, felonious conduct that is defamatory per se. Attorneys should not be permitted to destroy a person's reputation by alleging facts without a sufficient investigation or by failing to withdraw those allegations once it is clear that they are false and exceedingly that they are false or exceedingly unlikely to be true. Mr. Carter respectfully requests that the court vindicate Rule 11 by immediately dismissing the First Amendment complaint against Mr. Carter and imposing an appropriate monetary sanction or fee award against Mr. Buzbee and the Buzbee law firm. This could have all been avoided if you would have sat down for that confidential meeting before you was even named. I'm just going to start there. So whether or not you believe the allegations, I would have went to that meeting and say, "Hey, I didn't do this. I don't know who she's talking about." But you chose to ignore the demand. Therefore, they amended the complaint to add you, Mr. Carter. All right. Let's see. This is stuff that we already know. The hotline. So they're just talking about how and I'm gonna read this. I'm gonna read this pretty fast so we can get through this. So on September 17, 2024, federal prosecutors unsealed an indictment against Sean Combs for racketeering and other offenses related to sexual misconduct, none of which involved Mr. Carter. Shortly after, Mr. Buzbee published a 1-800 hotline for potential plaintiffs seeking to sue Mr. Combs for abuse. Just 2 weeks later, Mr. Buzbee stated in a press conference that more than 3,000 individuals had contacted him via the hotline claiming to have been victimized by Mr. Combs. Mr. Buzbee further stated that he was already representing 120 plaintiffs who intended to bring civil claims against Mr. Buzbee. That sequence alone strongly suggests that Mr. Busbee's vetting of claims were grossly deficient. Even assuming Mr. Buzbee set up the hotline on the same day that Mr. Combs' indictment was unsealed, the sheer number of calls that Mr. Buzbee allegedly received within the 2 weeks between the unsealing and the October 1st press release indicates that Mr. Buzbee could not possibly have vetted every caller's allegations to the extent necessary to establish their veracity before signing up 120 of them as plaintiffs. Now, Busbee's firm is not the only firm that is assisting in this. You will have several firms that are helping in this process. So I don't want people to think that it's only the Buzbee law firm that is working these Diddy cases. It is not. In the beginning, when I first reported this, I think I named about 2 other firms that were included in my video. All right. So Buzbee is not the only firm that is handling this. Let's get that clear. But within weeks of his press conference and in apparent rush to be the first attorney to get claims on file against Mr. Combs, Mr. Buzbee filed 15 lawsuits on behalf of individuals who contacted him via the hotline in this court alone. In addition to those 15 lawsuits, Mr. Buzbee also filed the original complaint in this case on October 20th, 2024. The complaint alleged that Mr. Combs, along with another unnamed male celebrity, raped plaintiff at a party hosted by Mr. Combs following the VMAs on September 7, 2000, while a female celebrity watched. In a letter dated November 5th and in the subsequent telephone conversations, Mr. Buzbee threatened to go public with false and defamatory allegations that Mr. Carter was the other male celebrity who had raped plaintiff and that he raped another minor. Unless Mr. Carter agreed to pay an exorbitant sum in private mediation, Mr. Buzbee anonymously, threatened to take a different course if Mr. Carter did not commit to the mediation within a mere 2 weeks. Unable to extract the payment from Mr. Carter for the false allegation, Mr. Buzbee then filed a First Amendment complaint on December 8th, adding Mr. Carter as a defendant without, as he now come to light, having undertaken even the most basic investigation of the allegation. I wish they would show us a copy of this demand letter because Buzbee is saying no monetary amount was even mentioned in there. But then you have Spiro saying that he was asking for money. And I've told y'all time and time again that there are demand letters that we send that only request a mediation to discuss some things, not necessarily a monetary demand. So this is crazy. The First Amendment complaint alleges that on or around September 7th, 2000, a friend drove plaintiff from her home to Radio City Music Hall to attend the VMAs, where she remained outside and watched the event on a Jumbotron. During the VMAs, plaintiff, determined to get into the VMAs or an after party, allegedly spoke with numerous limousine drivers to take her way in until she spoke with a driver who informed her that she fit what Diddy was looking for. When the VMAs ended, the First Amendment complaint claims that the same driver took plaintiff to a party hosted by Mr. Combs at a large white residence with a gated U-shaped driveway and a large living room or foyer. And I think I showed you guys that house in the Hamptons. At the party, the First Amendment complaint alleges that plaintiff recognized many celebrities, which she told the NBC News journalists, including musicians Fred Durst and Benji Madden, among others. The First Amendment complaint then recites the same rape allegation as the original complaint and alleges that the previously unnamed male celebrity who also assaulted her was Mr. Carter. It states that, following the alleged assault, plaintiff ran out of the house, passing numerous celebrities and other individuals on the way to a gas station where she called her father, admitted that she lied about her whereabouts, and asked him to pick her up. Plaintiff's father then purportedly arrived to pick her up shortly before dawn. My only question there is, why not call the police versus calling your father? I mean, I understand that you was 13 and you thought that you may have gotten in trouble, but if you ran to a gas station and you look scared or whatever the case may be as the clerk, why didn't the store clerk call the police? Mm. All right. On December 13, 2024, plaintiff sat for an interview, and I'll get to the comments in just a second. Plaintiff sat for an interview with NBC. The interview exposed that plaintiff had not, prior to the point, faced any meaningful scrutiny of her factual account. In response to questioning from NBC, plaintiff confirmed that many of the FAC's allegations did not correspond with basic, known, and readily ascertainable realities. For example, NBC reported the photos of Mr. Carter from the night in question shows him at the Lotus Club, not a private residence. Other photos from that evening also show Mr. Combs with his then girlfriend, the musician and actress Jennifer Lopez, at two different establishments, Lotus and Twirl, neither of which was a large residence with a U-shaped driveway. Plaintiff also claimed with certainty that she spoke with musician Benji Madden at the alleged party about his tattoos of the Last Supper. She supposedly remembers this interaction in clarity because she has a religious background, so it's something to talk about. But Mr. Madden was not even in the state of New York. His representatives told NBC that he did not attend the VMAs and, in fact, was on tour in the Midwest with his band, Good Charlotte. Plaintiff also asserted that when she could not gain entry into the VMAs on the night in question, she watched the award show on the Jumbotron outside. Photographs and videos, however, confirmed that no Jumbotron existed, as the city of New York denied MTV's permit request for one, and that when picking up or dropping off celebrities, limousines were cordoned off by police barricades and inaccessible to fans. Now I'm thinking, if did they show it on I don't know how to show. I have to look at the pictures. But did she get a Jumbotron mixed up with something? Possibly. That's what I'm thinking. But let's continue. Oh, you know what? Let me see. All right. Let me get to these comments. My bad, y'all. um, Fernando says obvious. It's okay. Okay. Pamela says it's obvious to me that Busby knows his stuff because he definitely said the other sellers sit there and watch who's a celebrity. Oh, God, I already read that. All right, Tima Marie. We used to sneak out all the time and never got caught. This is possible. Oh, Tima Marie, I was scared. My mama was. Fernando said a dad that cares enough to drive 5 hours to go get his child would have done a few things. One, he would have called the cops. Two, he would have taken her to the hospital. Or three, went back to the house. But that's the thing, though. She didn't even tell her father. And I can't say that she is lying about that because, once again, I was a teenager when something happened to me. I didn't tell nobody until I was 23. That's something I held too dear to, well, not even dear, but I held on to. So it could be that she just didn't tell. Now she's like, okay, I'm gonna tell you that I was somewhere I wasn't supposed to be. But in event if that did happen, I understand where she's coming from. I would have been too scared to even tell anybody because I don't even know how they would have reacted. And I'm just telling you this from experience. At T. Marie, yep, sneaking out and getting caught in the foolery by your parents, but sadly for some, it can go wrong and become dangerous. Exactly. Yes, y'all take a minute to hit the like button, please. Thank you. If Jay-Z fighting so hard to cover up all his dirt or keep his high profile image, I I think so too. Cause there's that Ramir case. There's some shady stuff that was going on with that. Did you see the interview of the former bodyguard for Diddy saying he was there and they didn't use limousines back then, only SUVs? I mean, you have to think, once again, this was a 13-year-old, but I understand what everybody is saying. However, can we get to the discovery phase at least so that way we can know for sure? Like, okay, I'm showing you pictures. Was it a SUV or was it a limousine? Because we no, actually, that is a lie because um that what was that part, that lady that just came out from Oklahoma? She showed a pic. Well, that was her. Did she win a limousine? I gotta go back and look, but we're gonna see. Bafana Duba, the 10 hours round trip would have needed the cars to refuel. Yeah, you right about that. Huh. Well, but back in them days, you put $5 in your gas tank, you had a half a tank. All right, so all of this would have caused any reasonable attorney to put the brakes on filing an inflammatory complaint and to conduct a more thorough investigation into plaintiff's allegations. Such an investigation would have immediately led the attorney to the first submitted complaint only identified witnesses of the alleged events, plaintiff's father. And even a brief call to him would have revealed, as an NBC News journalist immediately found out, that he was entirely unaware of the assault until the next week he was interviewed and had no recollection of picking his daughter up at a gas station. Given that plaintiff and her father were living in Rochester at the time, a 5-hour drive to New York City is unlikely that he would have forgotten about the incident it had actually occurred. He said to, he said so himself. I feel like I would remember that and I don't. That's something that would definitely stick in my mind. I mean, really? Like if it's just I don't know. I don't know. Do y'all remember any of y'all 5-hour trips? Y'all random 5-hour trips to anywhere? I don't know. Though he recalled an instance where he picked her up in the middle of the night, he remembers it as a local drive, not to New York City. Uncovering these serious problems with the claims who would not have taken a competent and ethical attorney much time. NBC journalists identified the complaint's factual inaccuracies only 5 days after the first admitted complaint was filed. But despite engaging in maximalist efforts to solicit new clients through his 1-800 hotline and extract an outsized payment from Mr. Carter under threat of taking a different course if he did not, that's the thing. It wasn't a different course. This is what happens, and Spira should know this. If you send a demand letter, you don't respond to the demand letter. That's an automatic lawsuit. Period. It's not a different course. It's something that is standard. Mr. Buzbee did not apply the same vigor to actually testing the specific allegations of plaintiff's case. Indeed, let me see. Let me see what this footnote says. So, Mr. Busbee's conduct in this case is consistent with his approach to pursuing high profile lawsuits. In a recent documentary entitled The Downfall of Diddy Inside the Freak Offs, he not acknowledged to reporters that criticism that he puts enough embarrassing things in a in a complaint to force a settlement was fair, and said that because the legal system is a gulag, his firm always makes an attempt to resolve these cases without filing a lawsuit. And if they fail in that, then they file the case and pursue it with aggression. I agree. That's all case. I don't care what case that is. I agree with what he said. Indeed, although Mr. Buzbee claims that his firm will continue to vet his client's allegations, he appeared to admit to NBC that his firm failed to conduct any investigation into the merits of the plaintiff's claim in the first place. Did he say that? Or y'all just saying that? It would have been simple to call plaintiff's father, review publicly available property records, or use a search engine to find photographs and videos of the VMAs from the night in question. But Mr. Buzbee apparently did not undertake even these basic steps. Now, I'm going to put a pause on that only because at those freak offs, they didn't allow for cameras or any phones to be taken, like, because y'all know it was the party and then the after party, the freak offs. Now the if we do a Google search for photos of any of Diddy parties, you will see like a camera person taking photos. But have y'all ever noticed anybody who is holding a phone? And one of the ladies who actually went to a freak off said they have to put their phones in whatever. I don't know if it's a case, so whatever they called it. So even though we can find photos of them being at the club, we're not going to find any photos of anybody at a freak off because they were not allowed to have their phones. Mhm. Instead of providing any justable, wait, hold up, did I? Da-da-da-da-da, da-da-da-da. Yeah. All right. So instead of providing any justifiable basis for this complete failure to comply with Rule 11, Mr. Buzbee has sought to shirk his Rule 11 obligations and foist blame onto another law firm, telling NBC Joe's case was referred to our firm by another who vetted it prior to sending it to us. He also attempted to make up his own lack of diligence by volunteering that his client would undergo a polygraph examination. But despite his routine social media updates about this case, he has been notably silent about whether plaintiff has sat for the test or what the results were. Following the publication of the NBC article on December 13th, Mr. Carter filed a pre-motion letter informing the court of his intention to immediately file for sanctions to dismiss plaintiff's First Amendment complaint and requesting that the court shorten Rule 11's 21-day safe harbor period to 1 day in light of the extraordinary and ongoing reputational harm inflicted by the complaint's false allegation of SA. 4 days later, Mr. Carter served a copy of his motion to Mr. Buzbee and all counsels of record via email. Though the court denied Mr. Carter's request to shorten the filing deadline, it permitted him to file this motion in compliance with the rule's safe harbor period, as you should have done that first. Since December 17th, Mr. Buzbee has not sought to withdraw the First Amendment complaint during the 21-day safe harbor period provided by Rule 11. This is a lot. Oh, wait. Let's see. That's a good point. No parent would forget that. Gotcha. Gold Digger said in the year 2003, all of the things she stated did happen. Party at Diddy's happened. The tattoo guy was at the party. The Jumbotron existed all in 2023. I need to look at that. It would have also been complicated to directly get the Manhattan or elsewhere. There were no smartphones, GPS at that time. That's true. The security and limo company also needs to be found. Yep. The other thing is the photos take a second to take and do not account for the entire evening. That's true. The drama is that both sides need to produce better facts that NBC had not produced. I agree. For instance, Benji has to be clear and say that he either did not have the tattoo or had not spoken to a young girl. Ooh, that's a good one. See, why didn't Busby show these results of the lie detector test? Yeah, well, we got to see if she even took the lie detector test. That's part one. The tour happened after the VMAs, and so it is not enough for them to say they were on tour because those dates don't align. Huh. I'm gonna do some digging into that. Hold on, this is the wait. I got my little notepad there. I'm gonna look into that 2003 date because that is a good question. Let's see. So these are the legal standards to ensure that lawyers do not file baseless and harassing complaints. Here what the federal Rule 11 says. By presenting to the court a pleading, an attorney certifies that to the best of person's knowledge, information, and belief formed after inquiry reasonable under the circumstances, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So this, I'm not going to read the whole legal standards, but all in all, what they're saying is in order for them to not file frivolous complaints that is filed to harass a defendant, the attorney who is filing has to ensure that they do their investigation, they do their due diligence to ensure that the facts can be supported, or that their facts, what is being alleged, can be supported. I get that. I really do. But once again, I'm going to state this is an SA case. And I think in one of the videos I did go over the SA case with the archdiocese. Uh-huh. It's a New York case as well. So this case is a little bit different because all of the facts aren't there. Well, I don't want to say that. Her allegations at this time cannot be supported by evidentiary support or evidence. Who we? Let me see. So the court should impose. So they want him to be sanctioned because he provided. All right, Mr. Buzbee signed in complaint, First Amendment complaint containing extraordinary, serious, and defamatory claims against Mr. Carter because so much of the narrative set out in the complaint is demonstrably false and other alleged allegations are highly unlikely. It is clear that Mr. Buzbee either knowingly filed a false complaint or failed to conduct a reasonable inquiry into the factual allegations. Mr. Buzbee all but admitted that he failed to vet the complaint and we was still searching for corroboration of the allegations, casting the blame on an unnamed law firm that referred him the case. Yet weeks after the interview aired, Mr. Buzbee failed to withdraw the First Amendment complaint or even move for admission into the Southern District. um Here it is clear from easily ascertainable, information that numerous allegations in the complaint were false or highly doubtful. By all indications, Mr. Buzbee did not conduct a reasonable investigation into the facts before signing the complaint. First, photographs obtained by NBC from the evening in question makes plaintiff allegations implausible in the extreme. According to the First Amendment complaint, the assault occurred at a party hosted by Mr. Combs in a private residence. But NBC reported that photos of Mr. Carter from that evening showed him at a party at a completely different location, the now closed Lotus nightclub in New York City. The First Amendment complaint description of the location where the party and purported assault occurred, a large white residence with a gated U-shaped driveway, which included a large living room or foyer and a hallway containing several rooms off of it, including a bedroom, bears no resemblance to the location or venue of the party where Mr. Carter was photographed that night. Moreover, Mr. Busby made it clear in a statement to NBC that plaintiff does not claim the assault occurred at the Notice Light Club. That's what I'm. I mean, it didn't like the Lotus. That's a nightclub. We're in talk about the residence. The residence is a totally different place. If it happened at a residence, they not gonna have their phones. The phones were not allowed in that house. I'm telling y'all. I don't care if it was in the Hamptons, whatever house she was at. No phones would have got past the front door people. The tour happened. Okay. The band Good Charlotte did in fact go on tour in 2000. Look it up. All right. Jay-Z had his own after party in 2003. Look up Jay-Z after party hosted by Remy Martin. Ooh. Yeah, the dates do not need to shift either. It may still be 2000 because then 2003 makes her 16 and she might remember that at least. Good point. The house may still exist when rugged. Nobody can be sure of the travel distance, time, direction, and that's what I'm saying. And these are the after effects. However, I'm not making Mr. Busby's case here. It remains plausible, and Mrs. Spiro and Mr. Carter were flailing too much, making it too suspicious to me. I thought I was the only one. The first camera phone was created in 2000, and they were extremely expensive. Hey, trust me, I know. I had my first. That's when I 2000. I was a freshman in college. And I didn't have a phone. I remember my phone wasn't even, you couldn't even take pictures. It was like one of those AT&T phones where you pull back the little cover and you access the keypad. That was about it. So I know damn well they so and that goes to show then that there was no phones, if there were, to be taking pictures. Even if you had a BlackBerry, I don't even think the BlackBerry took pictures. What's up, Buttercup? No, you good. You good. Huh, All right. Second, the First Amendment complaint account of what happened at the party before the alleged assault crumpled under even surface level scrutiny. The FAC alleges that upon arriving at the party, plaintiff encountered many celebrities in the large living room or foyer of the house. But when asked about whom she spoke with, she named Benji Madden, a conversation that supposedly stuck in her mind because of his readily I can't even talk, identifiable tattoo of the Last Supper. The entire exchange, however, was pure fiction. Mr. Madden did not attend the VMAs, was not at any party that evening, and was not even in the state of New York. He was halfway across the country on tour with his band Good Charlotte in the Midwest, performing at a concert in Chicago on the night of the VMAs, a fact that a Google search would have revealed in less than a minute. A competent lawyer would have asked the question, whom did you speak with at the party? During the first substantive discussion with plaintiff about her claim, and the other taken an effort to confirm that those individuals were indeed in New York that evening. But Mr. Buzbee apparently did not even bother to take that simple first step to investigate the claim before signing his name to a pleading accusing another person of a serious criminal offense. Now, that is not how lawyers are supposed to conduct themselves. that Nokia, you already know. Yup, that Nokia, baby, I thought I was the ish with that. Third, Mr. Buzbee evidently did not even contact the one witness that he both knew about and had access to, the plaintiff's father, who was more than willing to discuss the matter with NBC News. My thing is, even if he called the father and the father say, I don't remember that, what is he not supposed to pursue the case? This is the young lady's account of what happened to her. Yes, your job is to investigate. I get it. However, This is an essay case, and you don't take essay cases lightly. And when he spoke with NBC, he disputed a critical element of plaintiff's story, how she got home. The FAC alleges that after the purported assault, plaintiff ran to a gas station, called her father, admitted that she had lied about her whereabouts, and asked him to pick her up, after which he arrived to pick her up shortly before dawn, and the two drove home in silence. Probably she was asleep. I would be knocked out. When asked about the claim, however, plaintiff's father told NBC that he has no memory of this drive ever happening, even though it would have involved a 10-hour round trip to pick up his 13-year-old daughter from a random gas station. And like virtually any other parent, he was confident that he would have not forgotten such an incident. I feel like I will remember that, and I don't. Okay, we already talked about that. It is extremely unlikely that Mr. Busby spoken with plaintiff's father as part of the reasonable inquiry into the claim. The FAC would have alleged that he picked her up. The logical takeaway is that Mr. Busby elected to file a complaint without um, finding out whether the only identified witness could confirm plaintiff's story. Oh Lord, the fourth part. The FAC contains other allegations refuted by publicly available sources. For example, it claims that the plaintiff watched the VMAs from outside Radio City Music Hall on a jumbotron and spoke to limousine drivers to try to talk her away into talk her away into the event or later party. But photographs established that no such jumbotron existed. Uh, NYPD confirmed that MTV's permit request was the. Oh, can y'all see that? All right, so that is, I guess, the line, and then it was barricade. Here's the police officers, and then there's the limousines. Whew. Y'all don't find it funny that Busby wasn't at the interview with her? My theory is he knows the story is a lie. What lawyer let their client the interview without being? But that is the thing. I don't think she told. I honestly don't think that she even asked Busby to do the video or to do the interview. I've seen so many, and not just her. I've seen a lot of people on YouTube and everything giving out interviews while they are actively on in these cases. I I'm telling y'all now, like our firm, the firms that I contract with, they don't allow for anybody to go on any interviews without first seeking, permission. We ask that clients do not post on their social media. There's a number of things. So I don't even think that Busby was notified or anybody was notified that she was doing this interview, for one. Number two, now this is just my opinion. NBC probably contacted her and say, "Hey, we'll do an interview." Now I don't know if they pay people to do interviews, but that could be another thing as well. So I don't see Busby saying, "Okay, let's go ahead and sit down with NBC," because otherwise he would, or a responsible attorney that's working on the case would have been with her. But I don't even think that's the case. Oh, look at all them people there. And this is the VMA red carpet. I don't see nobody getting out them whatchamacallit, child. Let's see what this picture look like. Yeah, they had barricades. They had a lot of barricades, y'all. Oh, that's the real Slim Shady. Dang. Child. Look at all them Slim Shadies. Hi, kids. I bet as they're looking for this, they was probably jamming. That's crazy. Ah, Lord Jesus. The First Amendment complaint also describes a house with a U-shaped driveway located within 20 minutes of Radio City Music Hall, but public property records confirm that Mr. Combs did not own a residence at that time that matches this description. All of this information was in the public record before Mr. Buzbee signed the First Amendment complaint. Da 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 da. The fact that he chose to include each of these demonstrably incorrect facts in the complaint demonstrates that he failed to undertake inquiries to locate the publicly available records, photos, and videos that belie these allegations before the suit. So, yeah, so blase, blase, blase. Okay. All right. So, why y'all want him to have sanctions? I'm just going to sum this up so we won't be here too long. Um, That interview would have hurt Jay-Z if NBC didn't fact check her. Oh, you said it would have hurt. Hell, he is hurt. I bet money was involved and he got a cut. Lord Jesus. y'all better not do Busby. Hey, Alice RN. I feel like the judge gave him a warning about drowning the court in all these motions and belittling Jane's counsel. Busby also defended his position on what he used to assert facts in this case. That is true. That interview would have hurt Jay-Z if NBC did not fact check her. I don't think Busby knew NBC was going to fact check that woman. I honestly don't think that he knew that NBC was going to interview until the interview happened. They're all working together to take Jay-Z down. Diddy is hopeless. Case he's already gone. My thing is though, and through all of this, and I don't know if people are peeping this though, Diddy has not expressed anything. He has not said no, Jay-Z wasn't there. Am I the only person that is thinking about that? I'm just saying. This man publicly, well, not publicly, but he spoke out about Luigi being treated with respect and him not getting respect. But yet you have not came out and said Jay-Z wasn't there. The only person, but I guess if he said Jay-Z wasn't there, then you admitting that you was there. Child. Or at least be like, neither one of us was there. Or something. Neither one of us. I have to go back and read the answer because I want to see. I'm pretty sure that they denied it, but whew. um, the court should deny or dismiss the First Amendment complaint and sanction Buzbee because his conduct. Wait, Mr. Busby's failure to conduct anything close to a reasonable investigation of the claims here violates Rule 11. So, because this man did not properly vet his client, did not investigate the factual allegations, but yet signed a petition, the first amended complaint, and filed it with this court, that is, and so pretty much he did all of that, violated Rule 11. Therefore, Spiro is asking him to be sanctioned and dismiss the First Amendment complaint. That's all that this is talking about. I ain't gonna go because I ain't trying to keep y'all long. I gotta do some work and I'm hungry. My issue with this is, once again, they said Mr. Busby is a repeat offender. On October 14th, he filed a different complaint on behalf of an anonymous John Doe against Mr. Combs that has contained easily disprovable allegations. For example, the complaint asserted that John Doe had never been married, but CNN reported the contrary. He was married and his marriage purported ended after the alleged assault. This is information that an attorney could obtain during an introductory meeting with his client by simply asking questions about his marital history or how the alleged assault impacted his life. Oh my gosh. Yeah, I just want y'all to know that Busby ain't physically sitting down drafting all of this, okay, or taking these calls. So I do put blame on the other associate attorneys, paralegals, and legal assistants who ain't doing their jobs. Because this is embarrassing. I don't know. Because when we get clients in, I put them in the system. I ask everything: name, date of birth, address, email address. Is you married? How many kids you got? So on and so forth. Because one, if we do get to litigation, I ain't about to sit here and go back and ask you all these questions. But yeah, so I do agree with that. Wait a minute. The complaint also asserted that Doe was assaulted in 2006 in the Hamptons at Mr. Combs' white party. But again, CNN revealed that the white party was held at St. Tropez in 2006, and in the Hamptons 2007, something Mr. Busby could have learned simply through a Google search. It was only after CNN's reporting of the errors that Mr. Busby filed an amended complaint changing the year to purported assault to 2007 and the detail concerning those prior marital status. And that's the thing that, whew, if they get to the discovery phase, so if they, in the event that they do find out information during, before the discovery phase, then yes, amend the complaint to include that updated information. But if they go through discovery and they find out things, then yes, it would be updated. So if they go through discovery with Jane Doe and it comes that it's not the year 2000, it's the year 2003, then you'll amend the complaint to say it's 2003. That's it. Let the girl go to litigation. So whether we think she's right or wrong, or she's lying or she's telling the truth, at the end of the day, during discovery, that is going to help us determine what the truth is. And it will be supported by the documents, by the information, the photos, the videos, whatever can be obtained during that time. Her story will be corroborated by that. But if we dismiss the complaint, then we'll never know. Everybody would just run with the narrative that she is lying. Let me see. How are we supposed to know what he said? Well, that's what somebody said, but they listening to their calls, and y'all know that people be listening. They be like, "Ooh, if an inmate is listening to his calls, right? Then he tell his wife like, "Hey, babe, hey, dude in here mad because Luigi up here, because Luigi in the same jail as Diddy." So it could spread around, and they make them calls to their loved ones, and the loved ones tell somebody, that somebody tell somebody else, and next thing you know, that we all know. I think that's what it is. Good point. Has not said Jay-Z wasn't there. Nobody knows if is no, nobody is though. But Chuck, man, Diddy calling and he talking, people gonna talk. People gonna talk. I think this is a red herring. Mr. Busby is standing 10 toes down. Well, I smell something good. I'm hungry, y'all. Mr. Busby is standing 10 toes down and they are merely distracting him. I think so. Assuming their own innocence, they need to let it play out fair and square. That's all I'm getting out. That's all I'm saying. Let this shit play out. If you want to clear your name, let it play out. But I understand, as a defense counsel, you have to do everything in your power to get this case dismissed. You got to find all the loopholes to jump through in order to say, okay, let's get this case not the case, to get that First Amendment complaint dismissed that names Jay-Z as a defendant. That's all he's paid to do. Nothing else. I believe that woman was planted by Buzbee. That's just my opinion. Alex is still trying to litigate the case ahead of schedule. He is. He is. Yeah, that does happen. All right. Let's see. Let's see. Mr. Busby brushed away these glaring factual and that. Okay, so he did another case, and come to find out, the dude was married, and the year that he said it happened wasn't 2006. It was actually 2007. Okay, so that's it. Let's see. Why else y'all want it to be dismissed? Okay, so because of the NBC News article, he's still refusing to let the FAC go. No corroborating data can fix the problem that virtually every event in plaintiff's narrative is contradicted by an indisputable facts. At any rate, even if there was some reason to conclude that the complaint could be salvaged, the appropriate course of action would be voluntarily dismiss the complaint without prejudice under the Rule 41, while Busby determines whether the claims have a reasonable factual basis, not to leave a fundamentally defective and defamatory complaint on the docket while Mr. Busby does the work he should have done before he commits suit. So, meaning that, okay, if he even, let's see. So, if Busby wanted to conduct further investigation, all right, what Spiro is saying is that file a voluntary motion to dismiss the amended complaint without prejudice, do the investigation, and if you find what you need to find, ask the court to, well, not ask, file it again. That's what without prejudice. Now, if it was with prejudice, you wouldn't be able to file again. So without prejudice. But once again, I want to tell everybody this is an SA case. This is not a normal civil case. So there's actual case law and reasons as to why certain SA cases in New York do certain things. All right? So we don't have to believe her story, right? But because of the allegations, the nature of the allegations, it kind of follows a different path, but still sticks to the federal rules of civil procedure. Boy, Fernando, Fernando be killing me. Jay-Z will lose money if he let it play out of court. I agree. I mean that it, yeah, it is what it is. Alex wants to know the evidence so they can spin and discredit Doe. Uh-huh. I would let it play out so and could embarrass Buzbee in court. Just my opinion. And hey, if he gets embarrassed, he gets embarrassed. But that's the whole thing. Let it play out. Like I said before, this is a SA case. We can't take it like an actual regular, slip and fall, or no, this is those allegations have different um not procedures, but you have to look at that case a little bit differently. I have to see. I might do like a short video to kind of show y'all how they ruled, or because it was the same thing that happened in that archdiocese case. And because of the allegations that was brought forth, they couldn't treat it like a normal civil litigated case. Hey Ty, how are you doing? Yes, y'all tap the like button, tap the like button. All right, let me hurry up and get through this. Mm-mm-mm. Yeah, so they're just saying, hey, volunteer dismiss this, do your investigation. If you find what you leading, if you find what you're looking for, and the evidence that you find supports your plaintiff's story, go ahead and refile the case. Um, and then they're talking about him not denying, but not seeking admission. So bro don't even have an application, y'all. So he is admitted in the Eastern District of New York, but not the Southern District. I don't know what dude is doing, but he keeps, so because he hasn't filed that pro hoc application, he can't be signing his names on the pleadings. However, he is signing his name on these pleadings and he's filing them. So I don't know if there's something that we don't know, but I'm confused. And so they own his behind about this. Oh, wait. Okay. So his application is pending. So they're trying to question as to why he hasn't even sought an interim admission. I didn't even know there was an intern admission. So you can seek an interim admission pro hoc vice before or while your application is pending. Oh, he said, assuming that an application has even been submitted. I don't know. I really don't know about that. And there's no way for me to check. I could check all other districts, but for the Southern District, I can't check. Let me see. Finally, the nature of the allegations here warrants sanction. This is not a contract dispute or a patent case. This is an allegation of child rape. To sign a pleading accusing someone of such a horrific crime without adequately vetting the allegation, particularly when the defendant's prominence means that the allegation will be repeated in headlines across the world, is deeply wrong and unethical. If lawyers do not face consequences for such a caviar effort to destroy another person's reputation and inflict emotional harm on his beloved ones, that tactic will proliferate. So they saying pretty much make an example out of Busby. Together, these factors justify a strong sanction. That to end, Mr. Carter respectfully requests that the court dismiss the First Amendment complaint and impose monetary sanctions against Mr. Buzbee and the Buzbee law firm. Um, and here they are. They're citing cases in which sanctions was actually imposed. But once again, it's not no cases that are similar to this case. That's the only thing that's getting me. Dismissal is appropriate because the First Amendment complaint was not the product of a reasonable inquiry into the facts, and a monetary sanction would ensure some measures of deterrence of this sort of conduct in the future. This that sanction could take from that sanction could take the form of reimbursing Mr. Carter for his attorney fees and costs incurring and defending against this action. All right, so it's not going to be, well, it's up to the court on how they want to sanction him. If they want to say, okay, you have to pay $500 to defendant's attorney, but also you need to pay for his attorney fees and the costs that are associated for fighting this action. So they're not asking him to be, disciplined by the state bar or for the Southern District of New York. They're not talking about reporting him. They're just asking that he be fined. I think that's the best word to use. He be fined and pay for Jay-Z's attorney fees and the court costs. That's it. Oh, that was a long, child. That was a long. I ain't reading this declaration. So this is a declaration. All right, so these are the exhibits. Let me see. I think this is the NBC News article. We'll just briefly go through these. We ain't about to spend too much time. Look at them. Oh, buddy, buddy. Mm. Oh, this is the news article that who put this out? NBC. So this is the news article that was put out. They have so many pictures together, but they weren't friends or buddies. He said Sean Carter is the only person that can actually call him Sean. Okay. Make that make sense. Oh, okay. So this is the Lotus. Hold up. Let me pull this up so I could tell y'all exactly which one it is. All right. So picture two is all right. So this is Jay-Z at the Lotus nightclub. And what time is that though? That's the thing because after I keep saying it, after the show is the after party, and after the party is the hotel lobby. So what time was this? So he could have went to the Lotus, right? And then after that, they had a party at Diddy house. I don't care what y'all say. Like they said, it's always a party after the party. All right, so this photo is the awards ceremony at Radio Music City. You can kind of see where the limousines are. I don't too much see the barricades, but you can see that there's people. So I don't know about her accessing some things. We already watched these. So that's the crowd, and we see the barricades. Let me go through this. Slim Shady concert. All right. So I ain't reading no transcript. This is of the Chris Hansen show. What is this? Oh, this is them interviewing Tony Buzbee. So I'm not going through no transcripts. 7 is a transcript too of what? Of the press conference transcript. 8 is photos of the Twirl nightclub. I don't know what in the world she saw in this man. He just ain't my cup of tea. Photo by Henry McGee Globe. Because you know how we go to parties and you take pictures now, you see a phone in everybody's hand, right? Now, and she didn't have no, yeah. This is things that make you go, I'm going to get to the comments. Let me get to this. This is the deed. Wait, not the deed, but it shows Doc date. Is this the Hamptons? The Hamiltons, the Hamptons, Manhattan. Hmm. Mm. How many houses did this man have? This is the part. Okay. Wait, hold up. What is this? So this is the detail type deed collateral bureau. Good grief. $14 million. And this shows my hand. I think these are two different whatchamacallit. Whatever 813 Park Avenue is. Hmm. Exhibit 10 is the CNN article talking about the white parties, and I'm looking for photos. All right, so here's 813 Park Avenue. This definitely ain't it. Ain't got no darn it don't have no driveway. I'm exiting out of that. 12. That's a transcript. I want to see the downfall of Diddy. All right, so wait, 13. This is it. So y'all, okay. This is it. This is what I showed. This is the only White House. Now, from Radio City to this address that I put today is about a 2-hour drive. Now we gotta think. This is two how much? 24 years later. All of this, well, I don't want to say all of this, but the route could have changed. You see what I'm saying? However, that goes back to addressing the dates and times and the feel for the drive there and all that other stuff. So for her, 2 hours could feel like 20 minutes. We don't know. But this is the only thing that I looked and I saw it had a U-shaped driveway in the front. It has a U-shaped driveway way, and this is the only white residence. And I think in that video that I did that I kind of went it down my little rabbit hole. Um, the inside of the house has a large living room area, but I couldn't see exactly where the bedrooms. I ain't doing all that. So I'm thinking, what if this is the house? What if this is the house? Because he purchased this house in 1998, and he has had parties at this house. All right, let's go. It reads off as exactly what it is: intimidation. They want to discourage any other future lawyer from bringing any case against Mr. Carter. Okay, that's what I'm saying. They want to make an example out of Buzbee to scare off anybody who is thinking about suing Jay-Z. They are playing the man and not the game. Mr. Spiro is not doing a good job at counseling his disturbed and vulnerable client. Fernando said, Cap. All those other Marcy Croft and the rumored Bay Good donation happenings, they were them doing good, much unethical and professional. In the Ramir Godmother case, Mr. Carter concealed owning part. Exactly, I seen that. And so carefully, fully vouch for anyone. And that goes. I promise y'all. Let me click out of this. And now I'm gonna wrap this up so I can actually get to my me working. But the grandmother made a video a couple of weeks ago showing that people were showing up 4 o'clock in the morning ringing her doorbell. Like they have sued uh attorneys and judges because they were showing the whole thing was about jurisdiction. They clearly showed that Jay-Z had residence in New Jersey. They pulled up the property deeds, records, everything, but the court pretty much dismissed it. So this is not Jay-Z's first time, dealing with the courts. And so when you do things like this, it is suspicious. I don't care what nobody says. It is suspicious to me. So many excuses being made for this alleged victim. I'm always on the victim side, but when nothing makes sense, the response is, oh, she's autistic. And I get that. Guys, trust me, I get it. It does not make sense. However, we have to treat these are SA allegations. Well, yeah, SA allegations. So we cannot treat it as a simple civil case. I I can't remember. I can't even pull the video up. I want you guys to I might have to post it on my community. I need to see how to get this. But y'all need to read the Archdiocese case involving the SA and read what the Southern District of New York did in those particular cases and what they said. There are I'm gonna have to just I'm gonna link the video. I'm gonna link the playlist and I'm gonna let y'all know what video. What I'm gonna do is I'm gonna post a link to that video under this video so you guys can understand. I understand where everybody is coming from. However, we have to take it a step back and we have to look at the nature of this case. For instance, in a car wreck case, there's one that we're currently working on now, right? Individual was involved in a car wreck. On the police report, it is only him. However, he said his girlfriend was in the car. All right. We submitted a demand, and for the male, they offered something, but for the female, they were like, okay, yes, you have the injuries and all this other stuff, but how do we know that you were in the car? There's no cameras. The police report doesn't list you, all of that. So, as a plaintiff paralegal, I can't say, okay, well, I'm not going to include you in this lawsuit because we can't determine, because I've done my due diligence. Like, I'm taking her story, I'm taking what she says about the wreck. I don't know if she already coached, was coached by her boyfriend to say, hey, pretend like you in this wreck or whatever, blase, 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 right? But we have to take into consideration, okay, it's a possibility that you were involved in this wreck. So we have since then filed the lawsuit. I put in all the facts of the case based off of what she told me and what was on the police report. Now we're going through discovery. So once I think that's what I got to get off of here and do. So I have to draft a discovery request and production to their counsel, and then they draft it to us, and I have to get with them and I have to complete and get all the documents that they requested. After we have done that, then we go to depositions. Depositions is where our attorney deposed the defendant, and the defendant attorney deposes our clients. I'm telling y'all now, during that time, that is when we find out a lot of information. A lot of information. Be like, oh, you didn't tell us that in the intake process. And I have already done my due diligence. I have exhausted all things possible in order to find as much factual information that I can. But it is during depositions that we find out a lot more information. Okay? This is just a basic car wreck case that I'm telling y'all about. So if we go over to this SA claim, right? There's no way for us, yes, some of the little minor things, but we can't say that she was not essayed. That is her story. That is her allegation. Now, in order to prove her claim or support her claim, plaintiff's attorney, Tony Buzbee, will have a list of questions that Jay-Z got to ask. He will have a list of documents that Jay-Z has to produce. And it could be videos, it could be surveillance, it could be a whole slew of things. That is the time where we have experts come in and review all of this stuff. Well, can you sit down with her and can you, they have trained people who are in these and now I'm not even saying trained people, experts in those fields. If they need a psychologist or a psychiatrist to come in there and speak with her, that's what they're going to do. If they need for a, even though not a paternity test, damn, a lie detector test to be done, that's not admissible in court, but at least it will be done at that time. So we can say whatever we want, and it's not me taking up for anybody. I'm telling you guys the process. This is how it works. We can say all day, well, they're making up excuses or her story has inconsistencies. We haven't even got to discovery yet. That's what I'm trying to get people to understand. This is an essay case. This is not your typical civil litigation case. All you have to do is a simple Google search and say essay cases filed in the Southern District of New York. Take a read. Look how they, and you will see who ain't going to rebuttal an essay allegation against them. We had Roman Catholic Archdiocese, so many people have rebutted or tried to get dismissed a case involving essay against them. So for homework, this is the educator side of me. Google search essay cases in the Southern District of New York and take a read and see how those cases, the same thing that's going on with Jay-Z right now, so many other defendants have gone through that. And so many, like the courts, the judges, those jurisdictions treat the essay cases a little bit differently than they would do a regular civil litigated case. I'm just saying. I mean, don't talk. Hey, I don't do this for like, I'm telling y'all experience from what we have to go through. But also, it is out there. That information is out there for y'all to read. We can't treat this like a normal civil litigation case. The whole reason why New York came up with the Gender Motivated Violence Act is because the Supreme Court ordered the district court to come up with something that will help victims who were abused sexually. Y'all gotta go back and watch the other videos because I've talked about this. Fine. It's the end of the year. It's called tax write-offs. Speaking of that, I gotta do my darn end of the year stuff. A convenient coincidence. Then Ellen says people with autism do not behave in the same way, so I can appreciate people's personal examples of knowing people who have made mistakes. There are also autistic people who do not have these issues. That's correct. Autistic people do not all. Oops, I'm sorry. Autistic people do not all behave or present in the same way, so I can appreciate. Oh, you said that twice. There are personal experience with people who confuse easily and don't make mistakes and title. I gotta look back. I'm gonna put it in my link below. Yes, I know that you're talking about with the yes. Limo driver, you fit what Diddy looks for a 13-year-old white. Hey, now she okay. Listen, you said a 13-year-old white girl with special needs sound legit to me. Look, just because you're autistic does not mean that you look a certain way. Okay, let's start with that. Number two, you gotta. This girl snuck out the house to go to the VMAs. I'm pretty sure she did not look like she was 13 that night. I'm just saying. But how many of them challenged them to sue him criminally? In the year 2000s, phones were coming out and were flipped, not smartphones. No need to collect. Yeah, that's true. So either way, they couldn't even take a picture if they wanted to. If no new evidence is found, do you think this should get dismissed or at discovery, or should it go all the way to trial? Okay, so here's the thing. It's in the event that they go through discovery, they go through the what am I trying to say? The depositions. There we go. They go through the depositions, they have all their experts, and they do find that, it's sufficient in order to go to mediation, and that's one way. If it doesn't work out in mediation, then they go to trial. However, if during the discovery process that they find that they can't corroborate her story, then yes, a motion to dismiss can be filed at any time. There are certain deadlines that you have to file all motions with the court. So that all depends. And then YouTube had no camera or internet. Yeah, I remember that. I briefly remember that. That's why I was saying I had my little somebody said the Nokia 3000. Child, I thought I was the stuff for my little phone. But yeah, so this case, y'all already know I'm pretty excited, not because of this case, but this is probably one of the first cases that I'm actually staying on top of. But I am learning a lot in the process, and I do want to share what I learned with you guys. I do want to leave you guys with this. Y'all have to understand that this is an SA case. It cannot be treated as just a regular civil litigation case. So although she came out and said there are some inconsistencies in her story, or people are saying that they don't believe her, anything of that nature, we can't sit there because there's only a little bit of information that you need for an SA case in the Southern District of New York for it to continue. And that's why I say go and do your own research for SA cases in the Southern District of New York, and you see how some of these cases were ruled. Now, some of them were dismissed, and then some of them, they kept going. But I'm going to put a link to that video that I was discussing the Archdiocese case, so you guys can kind of have a better understanding of the SA cases, how they treat them in New York. So just keep that in mind. So yes, there may not be a lot of information. There may be inconsistencies with her story. However, this is an SA case. Okay. Now, somebody just can't come up and be like, oh, he did this to me, and we file a case. That's not how that works. You have to have some factual, some facts with it. Okay. Yes, this isn't like any other case because of her being autistic in every situation of the case. Yeah, and there's also cases. So not only search up SA cases in the Southern District of New York, search SA cases with people with disabilities in that particular jurisdiction, and read on how they came about that case. Read the complaint, read whatever motion to dismiss that was filed by the defense counsel, and read any decisions or orders that was made by the judge of that court. And then you can kind of have a better understanding of why we can't treat an SA case as any other civil litigation case. But yeah, hey y'all, thank y'all for definitely tuning in with me going over this. I know I can be a little long-winded, but I hope everybody understand, where we at in this case. Once again, Spiro has filed his motion for sanctions against Tony Buzbee, and just asking the court to say, hey, Buzbee, you filed a frivolous lawsuit just to harass Jay-Z, and you haven't been admitted in the Southern District of New York, you're going to be responsible for paying all of Jay-Z's attorney fees and court fees. That's pretty much what he's asking for. So sanctions and dismissal of the first amended complaint naming Jay-Z as the defendant. So it's not dismissing the whole case because the case is with Diddy. We can't dismiss the whole case. We can only dismiss the first amended complaint that named Jay-Z. But y'all tell me what y'all think. Y'all be going at it in the comments. I'll be cracking up. But definitely let me know what you guys think in the comments below. Don't forget to like, share, and subscribe. Thank you so much for y'all support. Again, thank you, thank you, thank you. Y'all be blessed. Bye.